So hello, everyone. Good afternoon from Hong Kong. Welcome to today's online workshop, which is organized by CTAC Hong Kong Arbitration Center. My name is Gentile O. I'm a Deputy Counsel at CTAC Hong Kong Arbitration Center, and I will also be the moderator today. Today's workshop is one of the CTAC Voice of Moot series events. We'll be looking at advocacy skills, which are critical either before a real arbitral tribunal or before a moot court tribunal. We are very excited to see that a lot of you who are field practitioners, as well as mooters who will participate in the forthcoming investment arbitration moot court, are joining us virtually today. So by the way, the final and the award ceremony of the 14th edition of the Frankfurt Investment Arbitration Moot Court, CTAC Chinese Mainland National Round, hosted by CTAC Hong Kong Arbitration Center, will take place in the afternoon on next Friday. You are all invited to witness the emergence of this year's champion. We have invited renowned experts to form the arbitral tribunal of the final hearing. Please save the links in the chat box, register, and make sure that you won't miss it. So today it is with special excitement and honor that we have invited Mr. Ren Qing, Ms. Adela Mao, and Mr. Damien McDonald to join the panel discussion and share with us the practical insights and experiences on what makes a good advocate and how to enhance your advocacy skills by mooting. After the panel discussion, we will reserve 10 minutes for Q&A. So you are welcome to raise your questions using the Q&A function on Zoom. So ladies and gentlemen, without further ado, please join us to welcome Mr. Brad Wang, Deputy Secretary General of CTAC Hong Kong Arbitration Center, to deliver welcome remarks. Brad, the floor is yours.
Thank you, Jing Tao. And ladies and gentlemen, dear mooters, dear lawyers and professors, thank you very much for attending this webinar online. I'm Brad Wang, Deputy Secretary General of CTAC in Hong Kong. For the welcome remarks, I have two tasks. The first is to basically introduce to you the host of this event, which is CTAC Hong Kong Arbitration Center. The second task is to share some of my thoughts or observations on the subject of this hour. Now, CTAC Hong Kong Arbitration Center was established in 2012. It is the first out of Chinese mainland sub-commission of the largest, most experienced, busiest, most reputable arbitration institution of China. We apply to CTAC arbitration rules to administer our cases. And when it comes to the procedural law, it is the Hong Kong procedural law that apply. So that's it. That's my first task. Short and simple introduction of CTAC Hong Kong. The second task for me today is to share some of the observations that I have for the topic today, what makes a good advocate. Now, having been working at CTAC Hong Kong Arbitration Center for almost a decade, I have had the luxury of observing a lot of advocates, a lot of lawyers arguing before us. And I'd like to share some of my thoughts. I won't touch upon the topics that my distinguished panelists are going to share in the next hour. So some very random and general thoughts for you, for most mooters. The first is that when we observe those advocates before us at CTAC Hong Kong, it's quite easy to observe some differences they boast comparing with the mooters in moots like FIEMC or this moot. The first is that they tend to appreciate the power of listen. I mean, they're all very good speakers. They're all very good advocates, but they emphasize on the power of listening. They tend to address the issues asked by the tribunal members and the arguments addressed by the opposing counsel. The second feature I often see from the advocates here at CTAC Hong Kong, which is quite different from the mooters, is that they tend to speak very slow, they tend to speak in a modest manner, and they use plain language when the arbitration language is English. And I think we have a lot of reasons to support these manners of speaking. They tend to speak slow because usually when it comes to arbitration cases at CTAC Hong Kong, it's usually a mixture of lawyers, clients, arbitrators at different cultures and backgrounds. It is always a good idea to speak slowly so that actually everyone is on the same page. They speak modest, they cross-examine the witnesses in a modest manner, because if, like what happened in some situations in the mooting, you become too aggressive, that might make the impression of bullying the other party, which is something we want to avoid in real life situations. And they use plain language. An example that I can give you is actually, sometimes we hear the tribunal actually criticize the counsel or the lawyers who are cross-examining the witnesses of the other side by using too complicated language or asking too complicated questions. They often interrupt the counsel and pointing out this issue. Use plain language, make sure everyone understands you, and move forward. So that's the second feature that I want to emphasize. The third is more off the table, more away from the hearing room, that I want to talk about the features of the advocates that we have here at CTAC Hong Kong. It is their personality. They are actually personal people, which are quite different from what you see, how they demonstrate in the hearing rooms. I mean, in the hearing rooms, they are sharp as razor's edge, but in real life, they're actually personable. They are easy to cooperate with. Why I want to emphasize this in front of the students is actually is that maybe as law school students, you are usually approached by your peers with real life difficulties, and they come to you asking you questions that they can't resolve. You are their last resort, and you give them your opinions. It's not technically a legal opinion, but you usually tell them what to do, how to resolve your peers' problems, how to tell the right from the wrong, let them know what is right, and you should do this, you should not do that, this is your right, this is their obligations. But that is the approach of when you are in the tune, when you are working as a lawyer, when you are providing legal help. That is not always the case when you are an advocate. When you are outside the hearing room, that might not always be the perfect way to face real life issues. You need to cooperate, you need to compromise. You need to sort of step back and reserve a little bit, because sometimes whatever comes out of you is actually the last resort you want to provide. That is, you don't always deal with issues and difficulties of life with the last resort. There are multiple other ways to go with first, then comes to what you are good at. So why I want to mention this is actually, we as a Moot organizer, the most questions we get asked are actually from students. And those questions we faced actually multiplied when comparing with real life questions we get asked by lawyers in actual hearings, in actual cases. And that is good because that shows students are quite shrewd. They're smart, and they have the very good legal senses. But that also concerns me, because after several years of practice, you will appreciate there are ways to deal with issues from alternative methods. And it's not always about it's your right or your obligation or just being that aggressive. So that's my third perspective. The feature of advocates, they are personable people. A lot of advocates are good advocates in that they are good in the in the adversarial system. They are good in arguing their cases and bring the best benefit out of their clients. Out of the hearing room, when we talk about how to build up relations with clients, with your team colleagues, or with other legal professionals in the team to strategically cooperate for a case, the personality issue matters, and that's my last observation. Before I conclude, I welcome every one of you, Mooters, for the upcoming FIAMC China National run by CTAC. And I like to quote a slogan I saw from the University of Hong Kong for this Moot, and that is quite insightful to my understanding. It was intended for HKU new students. It says, make HKU, make the University of Hong Kong your journey, but not your destination. I think that helps for Mooters. Make this Moot your journey, not your destination, because your future awaits you, and your future far away awaits you. For example, I might see you very soon in a CTAC Hong Kong administered cases. And I'll wrap up here. This is totally unscripted. This is actually my New Year resolution. I want to make all my welcome remarks not scripted. It now seems like not a good idea to me, but I just make a difference. Anyway, thank you very much. I can't wait to hear all the distinguished speakers to share their opinions, who are field practitioners, experienced practitioners, and highly relevant to discuss this issue. And Jingtao, back to you. Thank you.
Thank you, Brad. Thank you for very informative and exciting welcome remarks. Now, before we move to our panel discussion, please allow me to introduce briefly our distinguished panel. So today we are very honored to have invited Mr. Ren Qing to be our facilitator. Mr. Ren is a partner of Global Law Office in Beijing. He has been appointed on the panel of experts of the research base for international commercial and investment arbitration of the Supreme People's Court of China, and appears on the panels of arbitrators of several arbitral institutions, including CTAC, CMAC, BAC, SHIAC, and SCIA, etc. He has extensive experience as presiding, sole, and party-appointed arbitrator in domestic and international arbitrations relating to sales of goods, construction, investment, share purchase and repurchase, joint ventures, insurance, software, oil and gas, pharmaceuticals, and real estate. He also acts as counsel in commercial arbitrations, investor-state arbitrations, and WTO dispute settlement cases related to construction, real estate, mining, agricultural products, renewable energy, expropriation, and licensing. Prior to joining Global Law Office, Mr. Ren worked at the Department of Treaty and Law of Ministry of Commerce of China. Also, we are very honored to have Ms. Adela Mao and Mr. Damien McDonald as our panelists. Ms. Adela Mao is a barrister based in Hong Kong and holds PRC legal professional qualification. She is the ICC YAF representative for North Asia and has been appointed by the Secretary for Justice as a committee member on the Public Education and Publicity Subcommittee for the Mediation Steering Committee. Adela specializes in international commercial arbitration and civil litigation. She routinely acts upon instruction from Hong Kong solicitor firms and mainland Chinese law firms in high value and complex international commercial arbitration, frequently as sole advocate. Apart from counsel work, Ms. Mao regularly serves as tribunal secretary to the most senior and distinguished arbitrators in and outside Hong Kong in high-profile international commercial arbitration. Also, Mr. Damien McDonald is a barrister focusing on international arbitration and commercial litigation in Hong Kong, mainland China, and internationally. He also practices English law and international arbitration from Outer Temple Chambers in London. Prior to joining the bar, Damien was an international arbitration partner and registered foreign lawyer with Founder Partners in Hong Kong, and a senior associate with Herbert Smith Freehills in London, Shanghai, and Beijing. Damien is a fellow of the Chartered Institute of Arbitrators and on the HKIAC list of arbitrators. He is also a CEDR qualified mediator. So welcome, Mr. Yuan, Ms. Mao, and Mr. McDonald. The floor is yours.
Thank you very much, Jintao. It's my great pleasure and honor to be the facilitator for this panel discussion. I think before we start, I invite the both panelists to say very few words for the audience. Andela, I mean very brief, yeah.
Oh yes, I'm very honored to join Damien and Ren for the panel, and I will be discussing several issues. And I also welcome the questions from the floor. So I will talk to you later. Thank you.
Damien?
Thanks, Ren. I am also honored to join Adela and yourself in dealing with some of these issues. I'd like to thank Brad for his introduction, which also flagged up some of the points that I will deal with, some of the questions I'll be answering during the talk today.
Okay, thank you both. Yeah, indeed. Indeed, before this webinar, we discussed how to structure this panel discussion, and we prepare some questions which we believe will be interesting, will be helpful for the mooters to prepare for your upcoming competition. And also, we also hope that will benefit your future arbitration career. I mean, also not only for the moot, but also for your future real cases, help you to develop your advocacy skills. Okay, so the first question is a fundamental question. What are the essential qualities of good advocacy? Damien, could you share your observations?
Thanks, Ren. The way that I propose to answer this question is to deal with it in two ways. The first is to ask another fundamental question, and then based on that question, based on the answer, set out what we think some of the essential qualities are. So a fundamental point when thinking about advocacy is to ask what its purpose is. And as mooters and as junior lawyers, we usually skip past that and we start drafting because we need to get the job done and we need to be effective, and we effectively roll our sleeves up straight away. Before I talk about the essential qualities of good advocacy, I think let's ask, what is the purpose of advocacy? Well, in the context of arbitration and commercial litigation, it has a very clear and simple purpose. And if we can keep this in mind, that this will assist all advocates. Namely, it's to identify the issues in dispute, okay, from the pleadings and the materials, right? Then identify the points that need to be resolved to make a decision, to produce a reasoned award or a reasoned judgment, okay? So what are the issues? Then number two, what is the law relevant to those issues, to determine those issues? Then three, what are the relevant facts in the case that are going to be applied to resolve those issues? So pausing there, if you start every journey in advocacy with that purpose in mind, namely that you need to provide in everything you do a clear, coherent, logical and rational guide for the tribunal to write their decision. If you ask yourself those questions fundamentally in your case preparation, and you start with that as an outcome that you want to achieve, in the sense that the tribunal will take all of your submissions, starting with the written and then supplemented in oral, and use that in a credible way to write the reasoned award or judgment, then fundamentally you are on the right track. So that's the first overarching principle that I would set down to build the framework in terms of what are the essential qualities of advocacy. So to answer that question, it's actually relatively simple. So the essential qualities of good advocacy is everything that fulfills that purpose, right? Everything that can be used by the tribunal to write the reasoned award is good and essential advocacy. So conversely, anything that doesn't assist the tribunal to write that reasoned award in your client's favour is outside the scope of the essential qualities of good advocacy. Now, because we have mooters and we have junior lawyers, I'll give a couple of examples of what those things might be, because they come up a lot. Number one, too much background, too much context setting. A very significant amount of arbitration pleadings tend to have material that won't be really used in the award. Irrelevant materials that the tribunal does not need to refer to or apply in the making of their decision, okay? So if it's not going to be used, you must ask yourself critically, why is it in there? It sort of goes without saying. So again, from my primary point, identifying issues, facts and law. So poorly prepared advocacy, not identifying the issues, not tying the material and the law in a structured and coherent way that resolves the issue. Otherwise, you're not being coherent, logical, and careful in your submissions. Another couple of key points, and it sort of goes into slightly what Brad was saying in terms of being credible and trustworthy. You must be credible and trustworthy in terms of everything you do with the tribunal. One thing that doesn't constitute to good advocacy is overstating your case or using flourishes of advocacy that don't really assist your case. A very common one is to say someone's case is hopeless on X or Y point. I usually look at those sorts of submissions and my initial instinct, either as an arbitrator or as an advocate, is, well, you stating that they are hopeless doesn't really assist the position. If your advocacy gets you there in a clear, coherent and logical way, then I will conclude that they are hopeless. It's another version of name calling, and it's distracting and I'd leave it out. A related point, I suppose, is, and sort of comes up in mooting, but particularly with junior lawyers, is attacking opposing counsel or making personal attacks on the client or the opposing party. You must be very judicious in these sorts of dealings in advocacy. One, because the arbitrator or the judge is human and nobody actually likes this sort of engagement. Two, going back to my fundamental point, how is it relevant to determining the issues in dispute? Again, everything that's not going to assisting the tribunal to write the award isn't helpful. So in terms of the time for the first question, I think what I might do is kind of wrap up with some key points in terms of what are the building blocks for essential advocacy. And I think everybody's doing this already, but it's know and understand all the materials, identify all the issues in dispute, explain the law properly and coherently, show the tribunal how to address the issues. And then also one final point, when you're putting this together, remember that the tribunal members and judges are human too, and they will be attracted to a presentation of your case that makes sense from a factual, logical and commercial point of view. It should have a ring of truth and a ring of common sense about how you approach your submissions. Communication, I think Adela will come on and deal with that. Structure, I think Adela will deal with as well. But my final point in terms of the overall qualities, I think going back to what Brad said, and the points I have in my notes really echo his. Be credible and trustworthy, be likable and friendly. Why? Because dealing with a tribunal and a judge and your counterparty is one very complex conversation. And it's easier to deal with somebody who's actually properly engaging with you in a friendly and approachable manner. So that helps. So that's the answer to my first question. I'll probably go on about a minute over time, but
yeah, thank you. Damien, very helpful. And then do you want to add something, for example, within 1 minute?
Oh yes, perhaps I'll just add a brief comment on the one of the points that Damien has raised, which is not to use kind of exaggerate in your submissions, not to make rhetoric comments, which is not really assisting the tribunal, because I find that to be a common problem when I sometimes come across opposing counsel who is not trained or accustomed to a common law system of advocacy. You can find all sorts of arguments, all sorts of kind of name calling, emotional arguments in their submissions, but there's no substance. You need to give the tribunal a reason to dismiss the argument, that's all. You don't need to name calling. So that's just one brief point that I want to raise.
Okay, thank you both. Yeah, I think in one sentence, I think a good advocacy should provide reasons for the arbitral tribunal to write a award in favor of your client. Okay, so we know that basically advocacy consists of 2 parts. One is written advocacy, and the other is oral advocacy. So they mean how are written advocacy and oral advocacy different? How do they work together? Could you further elaborate this point?
Thanks, Ren. The first point to make is, in many ways, that they are of course fundamentally the same. Because going back to my answer to the first question, they must go to that ultimate goal of providing a clear, coherent, and concise guide to the tribunal to identify the issues in dispute, identify the relevant facts and applicable law, and then apply the law to the facts to determine the issue. So again, fundamentally, everything is going to that credible guide for the tribunal to write the award. Now, the thing about written submissions is that in international arbitration, they are by far and away the most significant part of the work by counsel in any arbitration. They will continue to be used. So no, let me pause there. So there's a fundamental importance to written materials because those are the materials that are the first and last impression for the tribunal. Again, applying our rule in terms of a credible and coherent guide. If you've written your submissions so that they apply the law and the facts in a structured and coherent manner, the tribunal will use them. So one, before you are at the hearing and begin speaking, you will have already persuaded, hopefully, the tribunal to be thinking in favor of making an award of your client. And the submissions should be structured in such a way that they have these submissions next to their desk throughout the hearing, making notes, at the closing, making notes. And then you may have closing submissions, but fundamentally writing the award. Your submissions should be so good and so helpful and so clear that they actually find their way into the award. So it is everlasting, everlasting is probably a bit hyperbolic or a bit over the top, right? But they are so fundamentally important because they stay with the tribunal long after you've had your ability to do your oral submissions. Okay, so how do we combine them together? Well, the written submissions are your first chance for your first impression to make your case. Your oral submissions are a chance to allow the tribunal to get to know the overall logic and coherence of your case. When I was talking about making sure things make sense commercially and logically, getting on your feet is a chance to have an engaged and one-to-one conversation with the tribunal on the issues, the facts and the law. And if it's done right, bearing in mind that there is a whole host of different arbitrators out there and different personalities, to an extent in every oral submission, there should be a very intimate conversation in terms of you helping the tribunal to understand your issues and to resolve the points that are troubling the arbitrator in writing their decision. So in this sense, oral submissions are very much a collaborative effort. You're not fighting the tribunal, you're helping the tribunal. This is the purpose of advocacy, going back to my first point. And better still, they want your help. They want you to be credible. They are asking you, please help me sort through some very complicated factual, legal, and other materials. Please assist me. So I think fundamentally that's the point. They are different, but they combine beautifully. One stays there for a long time and should be continually referred to, and the other is a real chance to enhance the trust and the comprehension of your overall logic in your case theory. So Ren, thank you. I think that was
thank you. Thank you, Damien. Yeah, now I will invite Andela to further elaborate each of the two parts, the written advocacy and the oral advocacy. So the next question is for Andela, how to think about and develop the best structure for written submissions.
Thank you, Ren. I will begin by saying that there are different styles of written advocacy and certainly different styles of oral advocacy. And I will reflect on the point that Damien has emphasized for multiple times. You should always think about what purpose you have in terms of making a certain written submission or in terms of making a certain oral submission. The purpose of your submission depends on the types of the application you're making, and certainly depends on the tribunal that you're facing. So there's a common phrase in the in the language of advocacy is to know your bench. That grows with your experience. You will know that, for example, certain arbitrators, certain judges prefer succinct submissions, for example, or you will know for perhaps some of them will prefer detailed legal submissions, or that they will prefer detailed factual analysis, or some of them just prefer you to go directly to the issues, and that will guide you in terms of the general styles that you will adopt for the written submissions as well as for the oral submissions. But that said, there's always somehow a style that is being used by counsel, which is used more often than the other styles. So essentially, in your written submission, in terms of a common structure, I would phrase it in that way. You will have an introduction. The core elements will include, at the beginning, you will have an introduction, which is to tell the arbitrator or the court what they are expected to do, what you invite them to do. as of the date of the hearing. For example, you invite them to make an order dismissing certain application. You invite them to do XYZ, and you need to tell them what you want them to do. And then the second one is a factual background, which is to set out the and I will go back to the point that Damien has emphasized. What purpose is your submission? For example, I guess the underlying principle for you to make a written submission is for that to get into the final award or judgment. If you think in that light, then you will know that the factual background will most likely include the undisputed factual background, because that will be the factual background that's in the judgment. It will be a general background to set the scene to lay the foundation for the following discussions, rather than a detailed discussion of all the factual disputes at this stage. So that is what you want to do. So the ideal written submission is something that the tribunal or the court can readily adopt for their awards, for their judgments. So that will usually be the second part, the factual background. The same applies to the third part, which is the legal principles. Then you will deal with, for example, you have a summary judgment application, and then you will set out the principles for the summary judgment application. And then the next one is very important. When you come to the detailed analysis, I learned this from a former judge who told the audience that he went to a judge's school when he was still a judge in Hong Kong, and then he learned judgment writing. So before he went to the judge's school, he thought he was very good, because he was very good. He was a senior counsel before his promotion to the bench, and he thought it was a routine learning for the judge, and he wouldn't actually learn anything. But to his utmost surprise, he said he learned one of the most valuable things in his career, which is to focus your analysis around issues. Because as Damien has already pointed to you, people sometimes get very distracted about the issues, because in any given case, there are always different levels of disputes. They dispute about the general background, they dispute about the application of the legal principles, and etc. They dispute about each and every sentence filed in the other side's correspondence, filed in the other side's submissions. But that does not necessarily need to end up in the judgment, because, for example, you have an application for summary judgment, then there will be certain issues for the court or for the tribunal to decide. They don't need to resolve each and every factual dispute. So you want to help them with that. And what I learned from that is that you need to organize your analysis around the issues, and then just go directly to the issues. Put yourself in the shoes of an arbitrator. When they're writing, just imagine that you are actually writing the award for them. So what will be the first thing that you will come to? And then you hope that they will adopt for their awards. So I guess that is the basic structure for written submissions. And obviously the tricks is to assist the tribunal, assist the court as much as you can. So you will provide very good page references for them, in the hope that if they want more details, they can readily refer to the voluminous bundles, to the detailed submissions or the detailed affirmation of facts by the parties, and they will have that material with them. So I guess that's the general account of the structure for written submissions.
Yes, thank you, Andela. Yes, Andela, tell us the ordinary and the common structure, introduction, facts, and the legal arguments, and how to present the legal argument. that is helpful. Okay, now we come to the oral submission. How to prepare for oral submission. And I think here, at this point, for oral submission, I want Andela to, to address this question from two perspectives. One is for a real arbitration, and the other is for the moot.
Yes, I'll start with the real practice because I think that might be easier because that follows from what I say about the structure of the written submission. You may have already realized what I said about the written submission is different from your moot submissions. So there, well, at the very beginning, that there are differences already. Just going along the line of the common practice or the best practice in real practice, when you have already, as Damien has told you, you have already filed your written submissions by the time of the oral submission. So what you want to do is to make very good use of your written submissions to assist the tribunal to understand the difficult components of your written submissions. Obviously, your oral submissions will be divided into different things. For example, opening, then closing, and they do have different emphasis. Generally, opening is to give the tribunal or the court an overview, a comprehensive overview of the issues. And when you come to the closing, you have already had the evidence from the witnesses. So you want to give them summaries. You want to give them conclusions on those issues. So there will be different emphasis. But generally, the point is to make very good use of written submissions. And by saying that, I mean, you don't need to recite your written submissions, that's for sure. You only need to refer to your written submissions. You need to constantly, in fact, refer to the written submission. For example, I have, you can tell the tribunal that the factual background is summarized at certain paragraphs of your written submissions. You can ask them if there is a need for you to go through, but in any event, if you find that there are some key facts that are really relevant to your application, and then you will say that you do not intend to, in a way, waste the time. You don't want to reread the factual backgrounds, but you just want to highlight several events. So I think that's a very effective way of using the written submission. The other point is to listen to the tribunal, listen to the opposing counsel, because we are often told that we make oral submissions in order to have a conversation with the tribunal. That, in fact, is very challenging because you will need to observe the tribunal constantly. You will see if they frown, for example, at certain points, and then maybe you will pause, and then you don't actually say that, I see your honor, or I see my lady, you may have a question about this point, but you say that I want to emphasize on this point because my lady, you will hear from the other side that they will say XYZ. My answer is XYZ, and then you make a reply to that. So I guess that is the general structure about how to prepare for oral submissions.
Okay, thank you. Damien, before we move to the next question, do you have anything to add for the? Okay, or we move to the next question. Yeah, in the oral submission or in the hearing, yeah, as Adela just mentioned, there is an opening, there is examination, cross-examination, and there is closing, but there is also a very important part that is to address the questions posed by the arbitral tribunal. So during the hearing, yeah, how to answer the questions from the arbitral tribunal.
Thanks, Ren. I think a lot of what I'm going to say builds on what Adela was saying, and then, of course, what I was saying in answer to the first questions. Before we talk about questions, I think fundamentally is good advocacy takes a lot of preparation, in the sense that you need to know all of the facts backwards, better than the tribunal, better than the other side, better than everyone. You need to know the law to the same extent. So preparation of the fundamentals, but then how they apply to the issues in terms of legal arguments, and then how the facts might be applied to the particular issue, how the law might be applied to a particular finding on the issue. You need to have absorbed that fundamentally as an intellectual exercise. That's what we've been talking about, and what I started with, and then what Adela developed. It's implicit, and everyone says, yes, of course. That's what we do as advocates. But just to bookend one side of this answer, I think it's important to understand that you won't have the ability to answer questions unless you've fully absorbed it, so that you can deal with from whichever direction the questions come from. So before I go on to answering questions, let me just give perhaps some further context. You will meet different tribunal members throughout your career, both in the moot profession and then in the broader commercial profession. Some will have understood the materials and done a lot of work and absorbed the materials so that they know it better than you. And they have seen things that you may not have seen, right? So that's one type of arbitrator. And then, or judge. And then people are busy because they're human. This is not necessarily a criticism. We're actually just dealing with people in a commercial enterprise. They may not have read the papers. They may not absorb them in the same way that you've absorbed them. They may have got some certain fundamental points back to front. You just don't know. And you need to be flexible in terms of keeping an open mind as to answering the questions, in the sense that if a question, so putting those two types of arbitrators on one end, but in terms of being asked a question, it goes back to the fundamental point. Your reliable guide in written and oral advocacy is assisting them to draft an award. So if they're asking you a question, it is for a reason. In the moot context, it may be to test your argument. It may also because they don't understand the law or the argument. In a lot of ways, it doesn't really matter. It's not a contest with the judge or the arbitrator. It's an engagement. And being helpful, if you can, so perhaps let's look at a structure for answering questions. One is, I think Adela said this, listen, make sure that you've comprehended the question properly. There will be nerves at play. I'm getting old. Sometimes I don't hear things the way that I think that I heard them the first time. Sometimes you might have nerves or adrenaline, or you might be looking at the next point and you're not listening properly. So you have a choice when you get asked a question. One, stop and listen. Calm down, breathe, comprehend. It's very difficult, but fundamentally, it cannot be an engagement to answer the question unless you've listened. And we're all human, so you must, as an advocate, understand that things might get in the way of you listening, being distracted, being nervous, thinking about your next point, disregarding the arbitrator's questions as not being relevant or not being helpful. It doesn't matter. Listen, comprehend. If you don't understand, ask for it to be asked again. Clarify it in your own mind and then understand it. Fundamental. It's like any conversation. How can you respond if you've not understood? It's something that happens all the time, and I don't think any of us above it, particularly me. I think it still happens to me in the sense of, for all the reasons that I put out, but listen, pause, comprehend. Gather your thoughts. An important point here is that a tribunal member has asked a question for a reason, okay? They've asked that question in good faith because they need help with the award, okay? Like in any conversation, if you don't think somebody has listened to you because they've responded just as you've asked the question, or they're thinking about what they want to say, well, one, it's incredibly annoying. Two, it's unhelpful. And three, fundamentally, doesn't answer the question. So put yourself in the arbitrator's shoes in the sense they're saying, I'm asking this question because, and it doesn't matter why they're asking the question, you need to answer the question. So in order to do that, it's important to listen, pause, gather your thoughts. Now, in the courtroom or the tribunal will not mind if you spend a moment to gather your thoughts. Pause, breathe, think about it, structure the answer in your head, and then answer. And if you do that properly and coherently, serving all the main objectives that we've all just discussed, then the question will be answered. If you don't do any of that, then they're going to ask another question. And then you're going to get into a situation in advocacy which is not good because you're not assisting the tribunal. You've not understood. They've not liked your answer. They think you're being evasive. You start losing these points that Brad mentioned in the beginning, which is credibility, trustworthiness, reliable. And a lot of these things can be solved by listening, understanding, pausing, collecting your thoughts. Now, just to wrap up, another, well, I think a final point given the time, wait to see whether there's a follow-up question. There may well be. Remember, it's a discussion, it's an engagement. Give the judge or the arbitrator the courtesy of saying, and have I assisted you? Just say, does that answer your question? You just need to pause. And then if it's proper engagement or dialogue, then they'll come back. And sorry, maybe one final question, one final point here, is it, if you don't know the answer and you've checked and you've thought that you've actually understood it, if you don't know it, that may be because your submissions are lacking in some way or otherwise. Say you don't know it. Fundamentally important. Because if you say you don't know it, then you maintain credibility. You may have lost a bit because you've not prepared this in your submissions, but you maintain credibility because they will say, okay, Damien doesn't know this. He will pause and you say, I'll get back to you after the break, or I'll seek instructions and I'll revert to you. But don't waste the tribunal's time. So in terms of not wasting time, I think I'll wrap up there and perhaps move on to
thank you very much. Okay, so for this, I have a question. Yeah, I mean, in real practice, do you, before you go to the hearing, do you prepare a list of questions in advance? Do you prepare, you predict what questions the tribunal will ask? Then you prepare some answers beforehand. Do you do this, or you just make yourself familiar with your written submission, familiar with the facts, with the legal issues? Yeah, what do you do?
Adela?
I was shaking my head because I wouldn't prepare a separate list of questions to be expected from the tribunal. I think by the time that you are ready for the oral hearing, you will know what kind of questions will be coming from the tribunal, because you have filed your written submissions, you have seen the other side's written submissions, and you will know that what are the points that are in serious dispute, and those are likely to be asked by the tribunal, because I consider it not economical to prepare a separate list, because you can't really bet on that. And there practically any question can emerge from the tribunal. So there's no point in just preparing a preset of questions or questions or answers and/or answers. The better way for you to do is to get familiar with your written submission, get familiar with the other side's submission, and then just to deal the point deal with the point on foot. Yeah.
Thank you. Yeah. Okay. Now we move to a question for you both. Yeah, for now most of the audience today are newcomers in this area, and some of them may before they registered for this Moot, maybe they know nothing about arbitration or international arbitration. So in your view, what are the common problems or common challenges for a newcomer with no experience or with little experience for international arbitration? Yeah, Adela.
I think we have covered many of the common problems already. For example, not listening to the tribunal, for example, getting too nervous in making the submissions. Just by doing that, I also want to raise a point which goes back to the last question, which is how to interact with the tribunal. Is my advice is that you shouldn't dodge the question, because one of the common problems in the moots, not in real practice, but in the moots, is that the students tend to ignore the question and then proceed with their own submissions. I know that there is a time constraint, and you are probably getting very nervous because you're probably thinking that well, for example, the question will be addressed by my other by the other opponent, by the other counsel, or you have already dealt with the question, or you don't think that the question is a proper question sometimes because you don't think it goes to the issue. But the proper way to deal with that is still to answer the question. If you have prepared a list of submissions and you will come to, for example, the tribunal gets very excited about your submissions, then they ask questions in bunches. For example, you have 3 main submissions. When you're making the second submission, they're asking you something about the third submission. When you're making a submission on legal principles, they ask you something about the facts, about the application of that legal principle in the case. And then the right way to do is, there are different ways of dealing with that. One way is to answer the question directly. The other way is to say, if you don't really want to break the structure of your submissions, then you will tell the tribunal that I will come back to that point. But at this point, very briefly, my answer is XYZ, but I will come back to that point because it relates to a later issue. You deal with the question, you don't ignore the tribunal in the moots. So I guess that's one of the common questions we have seen in the past moots.
Okay, Damien.
I'll hand over to Damien.
Thanks, Adela. I was trying to think about a useful piece of advice that I could give here. I think something that's common to everyone, mooters and practitioners, is nerves in terms of public speaking and dealing with difficult issues, difficult tribunals. Let's be frank, in lots of ways, a difficult job. And I think everything we've said today will reduce those nerves in terms of the well-prepared advocate is better prepared for anything that comes up in the proceeding. So you cannot underestimate the value of proper preparation. It'll make everything better on the day. So preparation is the key. There are other tips like make sure you record yourself. Don't read your submissions, have bullet points. Make sure that you've rehearsed your submissions a couple of times, even if it seems a bit silly. But hopefully the first time you make your submissions shouldn't be the first time that you've heard yourself speak them. I think it's very useful to do that. So at least you're not going to say them the same way, but at least you get the inherent logic and feel to what you're going to say out in the open. So there's a couple of key points in terms of dealing with nerves, preparation, rehearsal. Another thing too is get to the forum early, get to the hearing venue early. If possibly the day, a few hours before, make sure you're not running and setting up as you get there. Get there early, settle yourself, make sure you know which side you're sitting on, introduce yourself to opposing counsel, have your papers ready. You must do this well before the hearing starts and have yourself centered and calm. So I think that's it. I was going to make another point, and I'll just do so briefly. For those that are interested in advocacy, we have a wealth of material on the internet, particularly from the English bar, in terms of free materials in terms of advocacy, which anyone can go and find. There are also, once you start reading those free materials and looking on the internet, you'll find some wonderful and very famous books that give great advice to advocates starting out. I made great use of them, and I still do, in terms of reading and thinking about advocacy. So be inquisitive, read, and it doesn't come natural to anyone. You need to work at it. So that's one big tip, how to improve. Be curious and do lots of reading.
Okay, thank you both. And now we come to a next question. That is, in either in Moot or in real practice, yeah, you know, the councils, the councils have their colleagues to fight together. In Moot, normally there will be two councils at each side, and in real practice there will be in international arbitration there could be a large team working together. So how to collaborate with co-counsels in oral hearings? Could you please share your experience?
Yeah.
Damien first or Adela? Yeah, Adela first. Yeah, please.
Sorry. Sorry.
I'm sorry.
Yeah, in terms of Moot, I know that there is a requirement that you have to work with you have to demonstrate that you're working with your co-counsel. And the usual way of doing that is for the non-speaking counsel to keep the time and also to pass notes. But apart from Moots, I think in real practice, it really comes down to the structure of the team and what role you have in the team. Because in Moots, I take it that you are, in a way, really like co-counsel. There's no one who's leading or the other who's been led. You make submissions on different issues. And one of the common problems is we have seen is that when the tribunal asks a question which should be directed to the other counsel, the counsel who's being asked a question just panic, and he or she will be saying things which either not say anything or say things which are inconsistent with the overall strategy of their case. So my suggestion is that even if you have a division of labor between you and your co-counsel in the Moots, you will still know your counsel's case, and you think beforehand if your cases are consistent or not. Because very, very frequently, for example, you're making a submission on procedural issue and he or she is making submission on substantive issue. And at some point, your position might conflict, your position might have a clash, because you're insisting on thing A and the other side is your co-counsel will be making a submission on the opposite of the argument. We have seen that in the past. So my advice is that to think beforehand if your positions are consistent, because there will be no restriction for that for the tribunal to ask you any question that they wish, and they will assess if you have collaborated beforehand and you know the co-counsel's case well as. So that's part of the assessment. But when I say that real practice is different because you have allocated roles, so you have a leading counsel who will be, in theory, doing this, making the strategy of the case, and you have, for example, a first junior who's supplementing the skeleton submissions, who's preparing for the drafts, and you have what we call baby junior, a second junior who's helping with the with less substantive arguments. So real practice is different. I don't know if this is a good time for me to answer one of the questions addressed to me, which is, are we supposed to cite the opposing counsel submission, provide response to their points? I think if you are new to moots, if you're new to advocacy, you can just adhere to making oral submissions based on your written submissions. But if you are advanced, if you're experienced in doing moots, you should be responding occasionally to the other side's submission, even if you're a claimant or you're an applicant. So you speak first. You have already filed your submissions. You have seen the other side submissions. You will know what the issues are. So in making your submission, while you go through the list of issues in explaining your position to the tribunal, maybe there will be some good points, strong points of your case, and then you will tell the tribunal, on this point, the tribunal will hear from my opposing counsel that their argument is XYZ, that's a bad point because, and you deal with the point. And then when the ball shifts to the other side, and when the other side is not really dealing with your reply, and they're just reading from their original written submissions, then obviously the arbitrators will see that there is a difference in the advocacy skills. So I think that applies to the practice as well. I think this.
Thank you, Adela.
Yes,
thank you, Adela.
To Damien. Yeah.
Yeah, thank you, Adela. Yeah, Damien, do you have anything to add?
No, I don't. Sorry.
Okay. Okay. Thank you. So I think we cover most of the issues of advocacy, written advocacy, oral advocacy, how to structure and how to answer the questions, and what are the common problems, and how to work with your co-counsel. Okay, so I think the last question for you both is that come back to the moot for the moot competition. So overall, yeah, what I mean, in addition to what you have already covered, yeah, do you have any other additional recommendations for the students? Damien, you first.
No, not really. I would endorse all that Adela has said in terms of observations today, because I think also extremely helpful and a good refresher on fundamentals. I think today's lecture was kind of useful in reminding everybody of the fundamentals in terms of how and why advocacy should be prepared and delivered. And I think that in itself is a useful exercise.
Okay, thank you. Adela, do you have anything to add?
No, because I think I have said enough, unless I have any question from the floor.
Okay. Okay, thank you very much. I think we now, I think we can give the floor back to Jintao and ask Jintao to host and to say is there any further questions from the audience to Adela or Damien?
Thank you very much. Yeah, now I see that there is a question. Well, I think we just answered that question. Someone is raising his hand. Let me see.
I hope I have answered that.
Well, overall, I think I personally find it very informative and very useful and inspirational for all the topics and your answers. And there's someone raising hand. Let me see if. Eugene, you are raising your hand. So do you have any question to ask? All right, I think it was. Oh, never mind. So, okay, so I think the question in the Q&A box were just answered. And if you have anything to add, please feel free to also raise your question. Okay, so one more question from, okay, two questions now. So this is for Adela.
Yeah, I see the question.
Okay.
I can answer that directly. I hope I don't know if the attendees can also see the question, but generally, but very briefly, the question is about whether the counsel who's been picking up the other side's submissions will appear aggressive to the tribunal. And my answer is no. And I don't, in saying that, because you have heard that I mentioned you just pick up the other side's submissions occasionally. You don't pick up their submissions all the time. You pick up the main points, and the reason for you to directly answer those submissions is not to embarrass them, but to assist the tribunal, because you know that the tribunal will be asking the same question. For example, you say that for example, certain behavior is reasonable, and then you have seen in the other side's written submissions that they have listed a main reason to say that this behavior is not reasonable. You know that the tribunal will ask you, how do you explain XYZ? And then I think it's a good strategy for you to answer that in your submission. But then I don't think it necessarily shows that you're aggressive. You're just effectively dealing with the submissions. But on the other hand, if you're not dealing with your own submissions, but you're constantly dealing with the other side submission, I don't think the risk is that you look aggressive, but the risk is that you look disorganized because in your submissions, because the tribunal cannot follow, because they just hear replies to certain string of questions, and they don't have a structure in their mind. So my suggestion is that you keep a structure, and then within the structure, you deal with the main points, and that would be very effective, in my opinion. And there's another question, I think, for Damien. How is an arbitration moot different from a normal moot? Damien, if you would like to take this one.
Well, it's been a very long time since I've done a normal moot in a court. I think we might say 1997. So I'm probably not qualified to answer. Adela?
Yes, it's been a while, but I recently have done something which is similar to a court hearing, moot court hearing. I don't think it necessarily is different. I don't think it's different at all, unless apart from the fact that in a court hearing, if you're making a civil application, then you are only facing one judge. But in the arbitration, you have 3 arbitrators, all having their different minds, and they're throwing different questions at you. So I guess that's the difference. But in terms of advocacy skills, I don't see any difference in that.
All right, thank you very much. I think we've covered all the questions so far. So at the very end, I would like to invite all of you to take a group photo. Brad, if you could also turn on your camera, if you, so, okay. All right, so on 3, 2, 1, cheers. Well, thank you very much. I think we've done a very great and informative workshop. I wish I have the chance to attend such a workshop when I was participating in the Moot a few years ago, right? So at the very end, I would also like to extend a sincere thank you to all of you, to all the audience who have joined us online today. So I hope you find today's workshop beneficial, and see you next week. Bye-bye.
Best of luck.
Thank you very much.
Thank you.
Cheers.
Bye.
Thank you.
Bye.